Imagine this. During an argument, a husband tells his wife just to shoot him and get it over with. Concerned for his safety, she leaves the house and later contacts police to do a welfare check. Police arrive, talk to him, and convince him to go to the hospital. But as soon as he leaves, officers enter the house and seize his firearms without a warrant. But can they do this? Today, we're looking at a Supreme Court case that answers this question unanimously. But to understand why, we first have to look back at a very different case involving a crashed car, a missing revolver, and the birth of what is now known as the community caretaking doctrine. Let's get into it. Welcome to Cuffs and Case Law, where we read case law so you don't have to.
I'm Nate, and this is Dave, and we are cops. We are not attorneys. Today, we're talking about Cady v. Dombrowski and Caniglia v. Strom.
No,
So
this is
these
gonna
are
be rough
two
for
different
you.
cases. I know, dude. Yeah, it's going to be rough. But these are two different cases about community caretaking and whether or not evidence that's obtained during a community caretaking function of the police can be admissible into court. So that's the topic for today. Again, these two different cases, one's from 1973 and one is from 2021.
Wow,
which is pretty good
century
for us. Yes, we sure did. But of course, I can't talk about 2021 without talking about 1973.
Gotta lay the groundwork.
So, yep, we sure do. So that's the topic for today. Community caretaking is a very interesting topic in policing, and what it
Highly
boils
contested outside
highly
of policing.
contested. I think so too. Yeah, exactly. Because what it boils down to is good, bad, or indifferent. The police are responsible for a lot of different duties which do not involve the enforcement of law. I'm not giving my opinion on that. I'm just telling you that there are a lot of things that the police do that are not rigidly within the confines of the enforcement of the law.
Of law enforcement officer.
Yeah, correct. Right. So what is community caretaking, Dave?
Usually a function to provide some aid or
AIDS is a significant part
aid,
of it.
usually aid, but I'm also thinking shutting open doors for people when they request it, securing property, returning property,
Yep.
Any other type of function that is generally in the overall umbrella of aid, I would say.
Yeah.
Aid to the public.
Yeah, aid to the public is a huge part of it.
Which might be overstepping a traditional boundary, but given the circumstances, the context, if you will, we are allowed to do it.
So if I hear you correctly, what I hear you saying is that community caretaking is defined as a concept that recognizes that police perform duties unrelated to criminal law enforcement, such as assisting stranded motorists, conducting wellness checks, or securing unattended property, like you said. And that's according to Black's Law Dictionary, by the way.
That's your favorite dictionary.
It is. The community caretaking exception is where things get kind of interesting. So it's a Fourth Amendment doctrine that allows police to conduct warrantless searches or seizures when acting to protect public safety or the welfare of citizens rather than investigating crimes. So what happens when police are engaged in one of their community caretaking functions and evidence of a crime is discovered? That's exactly what we're talking about today. And we're going to go in depth. And
as we do.
Yeah, we're sure going to. So a couple things here about, for those that are not familiar or haven't really sat down to think about it, some of the community caretaking functions that police do has to do with vehicle safety, right? So administrative inventories of vehicles pursuant to agency policy, which is how it should be written in your report. And, towing, searching an abandoned or wrecked car to secure the owner's property, protect police from liability, right? Securing weapons is a big one. Seizing a visible firearm that's unattended.
What if the children found that shotgun?
Yeah. Won't somebody please think of the children?
Yep.
Trying to keep it from getting into the wrong hands. Roadway hazards, right?
Yep.
Stopping a motorist to check to see if they're lost or if they need assistance, particularly in out in the boonies and remote areas or times of super bad weather, right?
Or someone reports this person has driven around 4 or 5 times.
Yeah, exactly, right? You stop out. Yeah, you stop out with them and you're like, hey, do you need help? Do you need directions to get to somewhere? Well-being checks is a big thing that we do. Medical emergencies, right?
Yes.
So assisting sick or injured individuals found in the public, offering to give them a safe ride home. A huge one that I didn't really think of until prepping this is missing people.
Yeah.
Looking for missing people, right? That's not there's no evidence of a crime.
It's a daily activity.
It happens all the time, right? So that's a community caretaking function. That's a job that is given to the police that is not related to enforcement of the law.
Yeah.
So over time, the courts have recognized that, hey, these functions are part of policing, but inevitably, there's going to come a time where police are engaged in one of these community caretaking functions and they discover the evidence of a crime. So how do we manage that with respect to the Fourth Amendment? And that is what we're talking about today, right?
Let me guess. It's going to be a person that is passed out at the wheel.
No, dude. Well, no.
Okay.
This one gets... So I will preface it with this.
No,
we have covered some long case background, case brief details. Terry comes to mind, right? Yeah. I talked for what felt like an eternity about what Terry actually did.
Yeah.
This is by far the longest case detail explanation.
And it's the 70s.
1973. You will see there's a lot that goes on in here. And there's a reason why the outline of the case is so long. So you ready to get into the nuts and bolts of it, dude? Oh, there he is. That's pretty good.
A little bit better.
That was a little bit better. All right. First case we're covering, because we can't just cover one case as much as I would like that. But when it comes to this, we got to build. So first case we're covering is Cady v. Dombrowski. And this comes to us from 1973 and involves the arrest of Chester J. Dombrowski.
Hell of a name.
Yeah, it's a good name. Who was convicted in a Wisconsin state court of the first-degree murder of Herbert McKinney.
It's the Cuffs and Murder podcast now. You have abandoned robbery.
Hold that thought.
Okay.
We'll circle back to that. And old Dombrowski was sentenced to life in prison by the Wisconsin State Court. So this makes its way all the way up to the United States Supreme Court, and the opinion in the court was authored by Chief Justice William Rehnquist. This was a 5-4 opinion.
Ooh.
Yeah. So details of the case. You ready?
He also called his number.
Yeah, he called his own number, 100%. You ready for this?
Yeah.
Are you sure?
Oh, boy.
You need to stretch. It's going to be long.
She said. It's been a long time.
All right. On September 9th of 1969.
Yep. Outstanding. Nice.
Dombrowski was a member of the Chicago, Illinois Police Department.
Okay.
And he either owned or possessed a 1960 Dodge automobile. So put a pin in that. We got a Dodge. The Dodge is owned by Dombrowski, who's a Chicago cop.
Okay.
All right. On that date, he drove from Chicago to West Bend, Wisconsin, the county seat of Washington County, located some 100-odd miles northwest of Chicago. He was identified as having been in 2 taverns in the small town of Kewaskum, Wisconsin. I never pronounce.
So mad.
I know, man. I never pronounce Wisconsin towns correctly. I'm going with Kewaskum, and that's probably wrong. But that's 7 miles north of West Bend, and he's seen in 2 taverns there. At some time before noon, his Dodge
by noon, or the previous night,
the next day.
Okay.
So at the night before, he was seen at 2 different taverns on the night.
Okay.
On the 10th, at some point before noon, his automobile becomes disabled. His Dodge automobile.
Because it's a Dodge.
So he had it towed to a farm owned by his brother in Fond du Lac.
Oh, boy.
County?
There's no way.
I don't know. It looks awfully French. It's Fondulac. Fond du Lac County?
All right.
That's my best guess.
I'll allow it.
Anyway, it's next to Washington County. Who cares? His brother has a farm there, right?
Okay.
So he has his disabled Dodge towed to his brother's farm. Then Dombrowski drives back to Chicago in his brother's car.
Okay.
All right. Later that night, Dombrowski rented a maroon 1967 Ford Thunderbird at O'Hare Field outside of Chicago. Okay. And then he drove back to Wisconsin.
It's a lot of driving.
The next morning. So a tenant on his brother's farm saw the car matching the description of the Ford Thunderbird pull alongside the disabled Dodge at 4 a.m.
What the hell were they doing awake?
Paying attention to their neighbors. All right. So at 9:30 a.m., this is now September 11th, Dombrowski purchased 2 towels, 1 light brown, and 1 blue from a department store in Kewaskum.
Named?
No idea.
Unbelievable.
All right. So that night, he was in a steakhouse or a tavern in
Another tavern.
West Bend. Yeah, there's a pattern there, right?
Mm.
That'll be important here in a second. In West Bend, Wisconsin. He ate dinner and he drank apparently a lot.
Mm-hmm. As you would.
So he leaves the tavern and drove the 1967 Thunderbird out of the tavern in a direction away from his brother's farm.
Because he was drunk.
Yes. On the way, he crashed, believe it or not, with the Thunderbird breaking through a guardrail and crashing into a bridge abutment. So a passing motorist sees him. He flags him down, and the Good Samaritan drives him back to Kewaskum.
To avoid his OVI.
No, because the first thing he does is he calls the police.
Oh.
Dombrowski does.
Well.
So 2 officers pick him up at the tavern. Not a good look.
No.
And they drive him back to the scene of the accident. And on the way,
Crash.
Crash. On the way there, believe it or not, the officers noticed that Dombrowski appeared to be drunk.
Mm.
And he had offered 3 different conflicting versions of how the crash had occurred. So
the bridge jumped out in front of me.
They get to the scene, and they observed the 1967 Thunderbird crash there. They took various measurements for the accident, stuff like that. And
crash.
Dombrowski was, in the opinion of the officers, drunk.
Okay. Impaired.
Yes.
Call it.
And throughout the duration of that investigation, Dombrowski, of course, informed them that he was a Chicago police officer. So the Wisconsin policemen, they thought that Chicago police officers were required by regulation to carry their service revolvers at all times, so including off-duty. So after they call a tow truck to remove the Thunderbird, and they checked him, right?
Mm-hmm.
Didn't find the revolver on his person, so they looked in the Thunderbird, and he looked on the front seat, looked in the glove compartment of the car, and didn't find his service revolver. So the tow truck arrives. Thunderbird is towed to a privately owned tow yard in Kewaskum, approximately 7 miles from the West Bend police station. It was left outside, and no police guard was put on that vehicle. Okay? Are you tracking so far?
It's a lot.
It's a lot. All right.
But the context matters.
It sure does. So Dombrowski was taken to the West Bend police station straight from the crash scene. And he was interviewed by an assistant district attorney for some reason.
At some point in the morning.
Yeah. Oh, no, this is still the night of the 11th.
Okay.
To whom Dombrowski again stated that he was a Chicago police officer. And he was formally arrested for drunk driving, impaired driving, OVI, DUI, whatever they call it over there. He was in a drunken condition and incoherent at times. Because of the injuries sustained in the accident, the same 2 officers who were at the crash took him to a local hospital. He lapsed into an unexpected coma, and a doctor, fearing the possibility of complications, had Dombrowski hospitalized overnight for observation. So he's still in custody for drunk driving, right? But they took him to the hospital. He goes into a coma. They hold him there overnight. While that happens, one of the 2 cops that arrested him remained at the hospital. And the other one, Officer Weiss, this is after 2 in the morning now, drove to the impound where the 67 Thunderbird had been towed after the accident. All right?
And not guarded.
Yes. The purpose of going to the Thunderbird, and this was developed in the motion to suppress, spoiler alert, was to look for Dombrowski's service revolver. That was, Weiss testified, that's why he went there. And he testified that Dombrowski did not have a revolver when he was arrested, and that the West Bend authorities were under the impression that Chicago police officers were required to carry their service revolvers at all times.
So what? Just trying to caretake the gun being in a locked car?
Hold that thought, but yes. So Officer Weiss stated that the effort to find the revolver was standard procedure in their department of the West Bend Police Department.
To find guns of Chicago officers that are drunk in their city?
To not leave guns in cars.
Okay.
To not leave guns unattended in cars.
Yeah.
So Weiss opened the door of the Thunderbird and found on the floor of the car a book of Chicago police regulations.
Well, good. He was studying at the tavern, probably.
And between the two front seats, there was a flashlight, which appeared to have a few spots of blood on it.
Hmm.
So then he opens the trunk of the car, which had been locked, and saw various items covered with what was later determined to be type O blood. These included a pair of police uniform trousers, a pair of gray trousers, a nightstick with the name Dombrowski stamped on it,
Okay.
a raincoat, a portion of a car
That's
floor
not my
mat,
nightstick.
and a towel. All those things are covered in blood.
Oh boy.
And the
Good.
blood on
Oh no.
the blood on the car's floor mat was still moist.
Mm.
So the officer removes these items, takes them to the police station as evidence. So later that day, Dombrowski is confronted with the condition.
After his exit from a coma.
Yeah, he comes out of a coma. Hilariously, the Supreme Court just glazes over that. So,
because his mental state wouldn't be important to
right.
this.
So later that day, he's confronted with the condition of the items that were discovered in the trunk of the Thunderbird. He requested the presence of counsel before making any sort of statements.
Yeah, because he had watched our Miranda episode.
He did, and he knew. So after conferring with Dombrowski, a lawyer told the police that Dombrowski, quote, authorized me to state he believed there was a body lying near the family picnic area at the north end of his brother's farm.
What?
Yes. So Fond du Lac County police went to the farm and found in the dump the body of a male, later identified as the decedent, Herbert McKinney, clad only in a sport shirt. I don't know what a sport shirt is.
I would guess sport coat.
A sport coat?
I guess that's what they would call
Just
it.
a naked body with a sport coat on?
Maybe he was at a formal event.
Maybe it was a sport shirt. Maybe he had a jersey on.
Yeah. You could have said that. Context matters.
Yeah. Much darker note, the decedent's head was bloody.
Mm.
A white sock was found near the body. And in observing the area, one officer looked through the window of the disabled 1960 Dodge. Remember the Dodge? Located not far from where the body was found, and saw a pillowcase, the back seat, and a briefcase, all covered in blood.
Mm. That's unfortunate for him.
Yes. So police officials obtained on the evening of the 12th, returnable within 48 hours, not 72, 48, warrants to search the 1960 Dodge and the 1967 Thunderbird, as well as orders to impound both vehicles. So the Dodge was examined at the farm, and then it was towed to a police garage where it was held as evidence. The next day, criminologists came from the Wisconsin Crime Laboratory in Madison, and they searched the Dodge. They seized the back and front seats. They seized a white sock covered in blood, a part of a bloody rear floor mat, a briefcase, and a front floor mat. All those were seized, again, pursuant to the search warrant. A return of the search warrant was filed in the county court on the 14th, but it did not state on the return that the sock and the floor mat had been seized.
Someone forgot to add a few lines.
Yes. So at a hearing held on the 14th, the sheriff who executed the warrant did not specifically state that those two items had been seized in the execution of the search warrant. So at the trial, the state introduced testimony tending to establish that the decedent was first hit over the head and then shot with a .38 caliber gun, dying approximately an hour after the gunshot wound was inflicted. And so death occurred at 7 a.m.-ish on the 11th with a 6-hour margin of error either way. If you recall from all of this, that puts Dombrowski right in the area during the time of death. Dombrowski owned two .38 caliber guns. Dombrowski had type A blood, and McKinney, the decedent, had type O blood, which was
Whoops.
found all throughout everywhere. And that the blood stains found in the 1960 Dodge and on the Autumns found in the 2 cars were type O.
Because we didn't have DNA testing back then.
Right. Yeah, that was the best you got. So the prosecution introduced the nightstick discovered in the 1967 Thunderbird and testimony that it had traces of the type O blood on it. The portion of floor mat found in the 1967 car with testimony that it matched a portion of floor mat found in the 1960 Dodge. The bloody towel found in the Thunderbird with testimony that it was identical to one of the 2 towels purchased by Dombrowski on the 11th. The police uniform trousers and the sock that was found in the 1960 Dodge with testimony that was identical in composition and stitching to the one found near the body of McKinney on Dombrowski's brother's farm next to his 1960 Dodge.
It's not looking good for him.
There's a lot there, right? So the case was based...
I would call that probable cause.
Yeah, the state's case was based wholly on circumstantial evidence.
No.
So that is all of the background. There is a lot there. A lot of things happened in this 3-day period.
Yeah.
2 vehicles are involved. You have an OVI crash, DUI crash. You have all kinds of stuff going on, right? All right. So this first goes to Wisconsin state courts. And believe it or not, Dombrowski and his attorneys filed
a motion to suppress,
saying that the evidence was obtained during illegal searches of the vehicle.
Fruit of the poisonous
caretaking.
Caretaking. I was going to say revolver, but for the poisonous revolver.
Yeah, sure. So the Wisconsin state court denied the motion to suppress. And he was convicted of first-degree murder.
Sentenced to life.
Sentenced to life in prison. So he is displeased with this.
Did they ever establish a motive?
No.
Okay.
Not that is covered in this case.
Unbelievable. They covered every single detail,
they
but
sure
not
did.
the reason why he killed this guy.
Times and everything else. So the Wisconsin, Dombrowski is not pleased with life in prison, so he and his attorneys appeal up the flagpole to the Wisconsin Supreme Court. What do you think they said?
They denied it.
They denied
certiorari.
Denied? No. Okay. They affirmed the conviction.
Okay.
So they said
affirmed the denial.
Yeah. So the Supreme Court of Wisconsin, in reviewing the conviction on direct appeal, stated, quote, "Even though the evidence that has led to his conviction was circumstantial, we have seldom seen a stronger collection of such evidence assembled and presented by the prosecution."
It's a nice work, boys.
Yep, you did well.
Prosecutor.
Dombrowski, you're screwed, buddy. All right. So Dombrowski, believe it or not, is still displeased with this.
Yep.
He still doesn't want to spend the rest of his life in prison. So he appeals.
For a murder he doesn't remember?
Probably not. So he appeals up to the 7th Circuit Court of Appeals. What do you think they said?
Well, knowing that, I guess I'm assuming it got to the Supreme Court.
Sure
so I'm
did.
assuming they also denied his motion.
Actually, no.
Ooh, they reversed.
Yeah, so the United States Court of Appeals for the 7th Circuit reversed, holding the evidence obtained from a warrantless vehicle search should have been suppressed. So when he goes back looking for the gun, all of the stuff that he found on that initial search should have been thrown, is what the 7th Circuit says.
And such wouldn't have resulted in warrants for the property and all that other stuff.
Exactly, right? They wouldn't have even known.
No, they would have had no clue.
They would have had no idea. So now the state of Wisconsin is upset with the decision. So they petition the United States Supreme Court, who grants
certiorari.
They sure do. They would like to be more fully informed, if you will. All right. So 2 main questions are tackled by the United States Supreme Court in this case. Question number 1. Was the search of the Ford Thunderbird in violation of the 4th Amendment to the United States Constitution? 2. Was the seizure of pieces of evidence from the Dodge during the execution of the search warrant invalid because they weren't listed on the warrant's return? So those are the 2 different questions that the United States Supreme Court decides to tackle in this case.
I feel like that one's de minimis compared to the first one. You like that word
good.
Choice?
Yeah. Put a pin in that. You're learning stuff and things. We're not going to need to do this podcast anymore.
Feeling a lot better. So again.
Yep.
Much like the listeners.
Let's hope so, right?
Yep.
All right. So question number 1, was the search of the Ford Thunderbird in violation of the 4th Amendment? Supreme Court said no. All right.
Mm.
So
Motor-
let's get into why.
Okay.
So
They didn't go motor vehicle exception here?
no,
Okay.
no, they did not. We'll talk a little bit about that, but
That one's kind of already locked up.
yeah, different
So-
circumstances. Yep. So
It is not going to roll down the highway.
as you recall, and can quote verbatim, the Fourth Amendment
Mm-hmm.
provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So the ultimate standard set forth in the Fourth Amendment is reasonableness. In construing this command, there has been general agreement that except in certain carefully defined classes of cases, the search of private property without proper consent is unreasonable unless it's been authorized by a valid search warrant. So they're just setting the super basic ground rules of it's presumptively unreasonable to do a search of private property without a warrant, right? The baseline is no.
Searches without warrants are presumptively unreasonable.
Correct. All right. So the Supreme Court then says one class of those cases, which constitutes at least a partial exception to that general rule, is automobile searches. And although vehicles are effects within the meaning of the Fourth Amendment, for the purposes of the Fourth Amendment, there is a constitutional difference between houses and cars.
Yep.
That's quoting a case called Chambers v. Maroney. And then they quote a case of Preston v. United States and say that we made it clear that whether a search and seizure is unreasonable within the meaning of the Fourth Amendment depends on the facts and circumstances of each case.
Totality of the circumstances.
Yep. And they pointed out in particular that searches of cars that are constantly movable may make the search of a car without a warrant a reasonable one, although the result may be the opposite in the search of a home, store, or other fixed piece of property. So just Supreme Court's just kind of laying some groundwork there. And then they talk about how in their decision in a case called Mapp v. Ohio, which is from 1961, they overruled an older case of Wolf v. Colorado from 1949. So in Mapp v. Ohio, they said that the provisions of the Fourth Amendment were made applicable to the states
by the 14th Amendment.
Yes, the due process clause of the 14th Amendment and the application of the Fourth Amendment standards, which were originally intended to only restrict the federal government, also apply to the states. But that presents a little bit of difficulty when the searches of automobiles are involved, because when the feds are searching cars, it's almost always involves the detection or investigation of crimes related to the operation of the vehicle. That's how feds do cars. We, on the other hand, local and state police officers have much more contact with vehicles for reasons related to the operation of the vehicles themselves, right? When feds deal with cars, it's not about driving the car, right? When we deal with cars, it's almost always about driving with the car. So when you apply the Fourth Amendment standard, you can't do it exactly the same as you do with feds. All states require that vehicles to be registered. They require for operators to be licensed. They have extensive and detailed codes regulating the condition and manner in which motor vehicles may be operated on public streets and highways.
The feds allow traveling.
No.
Okay.
Because of the extensive regulation of motor vehicles and traffic, and also because of the frequency with which a vehicle can become disabled, involved in an accident on public highways, the extent of police-citizen contact involving automobiles will be substantially greater than police-citizen contact inside of a home or office. Some such contacts will occur because the officer may believe the operator has violated a criminal statute, but many more will not be of that nature.
Yeah.
Local police officers frequently investigate vehicle accidents in which there is no claim of criminal liability and engage in what, for want of a better term, may be described as community caretaking functions.
Crashes is where community caretaking came from?
No.
Okay.
It's just an example.
Okay.
So community caretaking functions, totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. So they're saying local police deal with cars all the time in what we are now going to call community caretaking functions. This is the first time that term has been coined. And they, again, kind of immediately define it as being totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. The constitutional difference between the searches and seizures from houses and similar structures and from vehicles stems from the ambulatory, which is a big word like mayonnaise that means capable of moving, character of vehicles, and from the fact that extensive and often non-criminal contact with automobiles will bring local officials in plain view of evidence, fruits, or instrumentalities of a crime or contraband. All right. Here, in this present case, being Cady v. Dombrowski, we must decide whether a search of the trunk of the 1967 Ford Thunderbird was unreasonable solely because the local officer had not previously obtained a warrant. And if it wasn't, we then must determine whether or not the warrantless search was unreasonable within the meaning of the Fourth Amendment. Because remember, just because there's an exception to the search warrant requirement, now we default to the reasonableness of that, right? So if a warrant is not required, then it has to be reasonable. So they're saying we first got to say whether or not
could he explain what he did?
Can you explain why you did what you did, and is that reasonable? That's his whole job, right? But first they're saying, look, did this require a warrant? If not, then when was it reasonable? So, and jumping right into that, the police had exercised a form of custody or control over the 1967 Thunderbird.
Was impounded.
Yeah, Dombrowski's vehicle was disabled as a result of the crash and constituted a nuisance along the highway. Dombrowski, being drunk and later comatose, could not make arrangements to have the vehicle towed, have it stored.
No.
So at the direction of the police, and for elemental reasons of safety, the car was towed to a private garage, right? Second, both the state courts and the district court found as a fact that the search of the trunk to retrieve the revolver was, quote, standard procedure in that police department to protect the public from the possibility that the revolver would fall into untrained or perhaps malicious hands. So they both agreed that the whole point of going into the Thunderbird in the first place was to try to get this gun secure so the gun wasn't stolen, the gun didn't fall into hands of, a child or anything. They just want
the child that's walking along the private garage and takes guns out of the trunk. Okay.
But that's the whole premise. The whole premise is they went in there to get this gun to secure it for safety. Although the trunk was locked, the car was left outside. And it was 7 miles away from the police department, and there was no police guard over the car. So it is, in theory, possible that gun could have fallen into the wrong hands. So the court said, particularly in non-metropolitan jurisdictions, such as those involved here, enforcement of the traffic laws and supervision of vehicle traffic may be a large part of a police officer's job. We believe that the Court of Appeals should have accepted, as did the state courts and the district court, the findings with respect to Officer Weiss's specific motivation and the fact that the procedure he followed was standard. So they're saying he should have just done that. And then, hilariously, the Supreme Court
could have found it the first time too.
True, but it was in the trunk.
No,
they could have done it,
but they didn't do an inventory.
If you remember, they searched him incident to arrest. They peeked in the glove box, peeked in the front seat, looking around for the gun. They didn't find it.
They have a policy about finding and securing guns, but not doing admin inventories.
That's, yes, kind of, is what we're getting at. All right. So then the Supreme Court hilariously goes on to just make fun of the Seventh Circuit for a while.
No.
It's great. It's worth a read. You should jump on, but it's not super applicable.
No.
But they make fun of the Seventh Circuit for a while. And then they say, all right, so we believe that this case, Cady v. Dombrowski, is controlled by the principles that can be extracted from 2 more cases.
Of course.
Those being Harris v. United States and Cooper v. California. So in Harris, he was arrested for
robbery.
Robbery. He sure was. I told you to put a pen in it. His car had been identified as leaving the site of the robbery. It was impounded as evidence, and a regulation of the District of Columbia Police Department required that an impounded vehicle be searched, that all valuables be removed, and that a tag detailing certain information about the vehicle be placed on it. So, in compliance with this regulation and without a warrant, an officer searched the car and, while opening one of the doors, spotted an automobile registration card belonging to the victim of the robbery lying face up on the metal door stripping. So this was introduced into evidence at Harris's trial for robbery. In rejecting the contention that the evidence was inadmissible, the court stated the admissibility of evidence found as a result of a search under the police regulation is not presented by this case. The precise and detailed findings of the district court accepted by the Court of Appeals were to the effect that the discovery of the card was not the result of a search of the car, but a measure taken to protect the car while it was in police custody. Nothing in the Fourth Amendment requires the police to obtain a warrant in these narrow circumstances. Once the door had been lawfully opened, the registration card was plainly visible. It has long been settled that objects falling in the plain view of an officer who has a right to be in the position to have that view are subject to seizure and may be introduced into evidence. So that was Harris.
No.
The other case, Cooper v. California, right? So in Cooper, the petitioner was arrested for selling heroin, and his car was impounded pending forfeiture proceedings.
Santana.
Right. So a week later, a police officer searched the car and found in the glove compartment incriminating evidence, which was subsequently admitted at the petitioner's trial. The court upheld the validity of the warrantless search and seizure with the following language. This case is not Preston, nor is it controlled by it. Here, the officers seized Cooper's car because they were required to do so by state law for forfeiture proceedings. They seized it because of a crime for which they arrested Cooper. They seized it and impounded it, and they had to keep it until forfeiture proceedings were concluded. Their subsequent search of the car, whether the state had legal title to it or not, was closely related to the reason the petitioner was arrested, the reason his car had been impounded, and the reason it was being retained. The forfeiture of his car did not take place until over 4 months after it was lawfully seized. It would be unreasonable to hold that the police, having to retain the car in their custody for such a length of time, had no right, even for their own protection, to search it. So Harris and Cooper, these two decisions, the Supreme Court said these are really guiding principles here in Cady v. Dombrowski. They said these decisions, while not exactly in line with the current case, lead us to conclude that the intrusion into the trunk of the 1967 Ford Thunderbird at the garage was not unreasonable within the meaning of the Fourth and 14th Amendments solely because a warrant had not been obtained by Officer Weiss after he left the hospital at 2 a.m. The police did not have actual physical custody of the vehicle, as in Harris and Cooper, but the vehicle had been towed to where it was towed at the officer's direction.
No.
These officers are in a rural area, and they were simply reacting to the effect of the crash. One of the reoccurring practical situations that results from the operation of motor vehicles, and something that local police officers deal with every day. The Thunderbird was not parked adjacent to the dwelling place of the owner, nor simply momentarily unoccupied on the street. Rather, like an obviously abandoned vehicle, it represented a nuisance, and there was no suggestion in the record that the officer's action in exerting control over it by having it towed away was unwarranted, either in terms of state law or sound police procedure.
Yeah.
So they're saying, no, this was good to go for them to tow it. In Harris, the justification for the initial intrusion into the vehicle was to safeguard the owner's property, Harris's property. And in Cooper, it was to guarantee the safety of the custodians, the police, right? To protect them from liability. Here, in Dombrowski, the justification, while different, was as immediate and constitutionally reasonable as those in Harris and Cooper. In this case, it was concern for the safety of the general public who might be endangered if an intruder removed a revolver from the trunk of the vehicle. Furthermore, as there is no record basis for discrediting such testimony, it was corroborated by the circumstantial fact that at the time the search was conducted, Officer Weiss was ignorant of the fact that a murder, or any other crime for that matter, had been committed.
Yeah.
So they're
He
saying,
wasn't going looking for evidence.
how can he look for evidence if he doesn't know that there's a crime, right? There's not evidence of drunk driving inside of the car that he's going to go search for. They saw inside, right? He went in the front seat. He went in the glove box. So he straight up testified that, hey, police procedure, I need to secure this gun. The whole reason I went there was to go get the gun. And they're saying there's nothing to discredit that testimony. They say, look, perhaps in a big metropolitan area, the responsibility to the general public might have been discharged by posting a police officer to guard the car overnight.
Not sure who does that.
Exactly. That's what they're saying. What might be normal police procedure in such an area may be neither normal nor possible in Kewaskum, Wisconsin. The fact that the protection of the public might have been established or accomplished rather by less intrusive means does not by itself render the search unreasonable. So just because you could have put a cop there doesn't mean it's unreasonable to go try to get this gun out. The court's previous recognition of the distinction between motor vehicles and dwelling places leads us to conclude that the type of caretaking search conducted here of a vehicle that was neither in the custody nor on the premises of its owner and that had been placed where it was by virtue of lawful police action was not unreasonable, solely because a warrant had not been obtained. The framers of the Fourth Amendment have only given us the general standard of unreasonableness as a guide in determining whether searches and seizures meet the standard of that amendment in those cases where a warrant is not required. So they've already said, no, he didn't have to get a warrant. So now they're saying reasonableness is all we got to go on. So whereas here, the trunk of an automobile, which the officer reasonably believed to contain a gun, was vulnerable to intrusion by vandals, we hold that the search was not unreasonable within the meaning of the Fourth and the 14th Amendments. So that answers question A in a really long and roundabout way. But they said no. They went there to go get the gun. Getting the gun is reasonable as a community caretaking function of the police.
Given the circumstances.
Given the circumstances of this case. And they did put a little gold star next to the fact that Officer Weiss didn't know that a murder or any other crime had happened. So that answers question 1 of the United States Supreme Court, which brings us to question 2. Question 2, to remind you, was the seizure of pieces of evidence from the Dodge during the execution of the search warrant invalid because they weren't listed on the warrant's return?
No, because it's just a small administrative error and it's not a big deal and it doesn't affect your Fourth Amendment rights.
Man, I could almost skip a lot of what I have here because that's exactly what they said.
Now it's the short version. You're welcome because I got it right. Everyone that's listening,
or
watching,
they go back and
forth. You now can watch on Spotify and YouTube.
Oh, look at that! Dropping that plug. That was good.
Thank you, Spotify, for hosting. Now,
yes, that is a cool new thing about the show. They go through what the various courts thought, and I was going to introduce a new term to you, which is functus officio.
Spell that out for everyone.
Functusofficio. Functus officio, which is a Latin legal term that literally translates to having performed his or her office. Refers to an official, judge, arbitrator, or agency whose mandate has ended because they completely fulfilled the specific duties for which they were created or empowered. So the Court of Appeals held that the seizure of the 2 items could not be justified under plain view doctrine. They said that once they had once the warrant to search the Dodge had been returned, it was game over. So it was ticky-tacky because the warrant was obtained on the 12th. The actual search occurred sometime on the 13th. They don't know when the actual return was filed or was completed, but it was filed on the 14th.
Okay.
And so I will jump to the end here. And the Supreme Court says, the record is so indisputably clear that the return of the warrant was filed on the 14th, not somewhere prior to the search on the 13th.
Mhm.
And we are somewhat at a loss to understand how the Court of Appeals arrived at its conclusion. The warranted search
Nothing less than sheer torture of the English language to come to that
Yeah.
conclusion.
So again, they're making fun of the Court of Appeals. The warrant to search the Dodge was issued on the 12th, and although a return of the warrant was prepared by Fond du Lac County officer sometime on the 13th,
Mhm.
it was not filed in the state court until the 14th, at which time a hearing was held. The seizure of the sock and the floor mat occurred while a valid warrant was outstanding, and thus could not be considered unconstitutional under their theory. As these items were constitutionally seized, we do not deem it constitutionally significant
De minimis.
that they were not listed on the return of the warrant. We therefore do not need to reach the question of whether the seizure of the two items from the Dodge would have been valid, because the entire car had been validly seized as evidence
Yeah.
and impounded pursuant to the warrant. The judgment of the Court of Appeals is reversed. Big case, right? Because it introduced community caretaking into policing, and it said that, hey, we have some guidelines that we need to follow, but if you are looking in a vehicle for a gun that you reasonably
should be
believe is
there.
there,
Yeah.
right, and you are trying to do that to keep it out of
The wrong hands.
that is a community caretaking function of the police, and any of evidence that is lawfully observed or obtained in the performance of that caretaking function may be introduced.
To me, it's so weird that something so unique, like a drunk officer who crashed gun that's in his car at an impound
murdered
lot,
a guy
who murdered a guy
and
is
had two
who
different
creates
cars.
Community caretaking.
It's wild, isn't it? Yeah, it's absolutely
That's why
wild.
you tune into the Cuffs and Case Law podcast, so you
Yeah.
can be more fully informed on where
because
the stuff comes from.
because the context matters.
Because the context matters. Let's just hit every single ding we can.
Just right in a row. Just fire them from the
Shotgun.
hip. That's right. Cady v. Dombrowski is a big case, but it only involves motor vehicles.
Mm-hmm.
So we made it from, what was that, 1973, I think it was, right?
1969.
Well, 73 is when the decision came down, right?
Yeah, but we care about when it started.
So we made it from 1973 to 2021. That is a lot of years, 48 years.
Before the Supreme Court took on community caretaking again?
No.
Oh.
But before they took on the big one, which is, what about a house? Right?
Searching a house?
Community caretaking
to
function
a house?
to a house.
Oof.
But again, we went from 1973 to 2021 before anybody answered that question. Thankfully,
because they always shot them down and said this is the this is the whatever the most important
so
thing.
We got two extremes on this episode of Cuffs and Case Law. We have the longest case brief,
and now the shortest,
decision that I have personally read.
What about Hester? That was 3 paragraphs.
Oh, you're right. We need to go word for word and see which one's shorter. Can you annotate it? Can you put it right here?
I'll put 2 counters up.
All right. Well, this case is Caniglia v. Strom.
Via Justias.
Caniglia v. Strom of 2021. So I need to know right here, is it shorter or is Hester shorter? All right. So this case involves a lawsuit against police officers by Edward Caniglia after officers entered his home and seized his guns.
Yeah. Second Amendment.
Actually, not even touched.
Interesting.
Yeah, I know, right? That your brain immediately goes there of like, oh my gosh, now we got the 4th and the 2nd and the 14th. Like, goodness gracious, we got a lot of things going on here, right? No, it does not touch on that. But Justice Clarence Thomas delivered the opinion for a unanimous court on this one.
9-0.
9-0. Doesn't happen all the time. So when it's a 9-0 decision,
knockout.
Yeah, it's a knockout punch. You should probably pay attention because they're pretty clear on it.
I get why the other one was 5-4.
Yeah, right. Because there's a lot there. Again, we don't cover dissenting opinions in Cuffs and Case Law podcast. I don't recommend that in the early stages of your journey of reading and studying case law. I don't recommend that you even read dissenting opinions. No. Once you get further down this rabbit hole, it can be very interesting to read dissenting opinions, especially on a 5-4 decision when it's really, really close. But the decision's the decision. So I don't recommend that you read them. But in this case, it's unanimous. So you should definitely pay attention to that. All right. You ready?
Let's do it.
All right. So during an argument with his wife at their Rhode Island home, Edward Caniglia, who is the petitioner, retrieved a handgun from the bedroom, put it on the dining room table, and said, why don't you just shoot me now and get it over with?
Damn.
Yeah. So Mrs.
It's called raising the stakes.
Yeah, Mrs. Caniglia declined, and she decided instead to leave and spend the night at a hotel.
That is the correct move.
Next,
Miss Lady.
Miss Caniglia. So next morning, she tries to call old Ed, and Ed doesn't answer the phone. So she gets a little bit worried, and she calls.
She thinks he shot himself.
Yeah, sure does. So she calls the police to do a well-being check on him.
She ain't walking in there.
No, but she accompanied the officers. So the officers accompanied Caniglia's wife to the house where they encountered Caniglia on the porch.
Okay, not dead.
He's sitting on the front porch.
And they said, goodbye.
No.
Because that's how we make case law.
Correct, yeah. If they'd just been like, hey, bro, you going to kill yourself? And he was like, nah. They'd be like, sweet, see ya. We have no Caniglia be strong.
Yeah.
But he spoke with the officers and confirmed his wife's account about the argument, but he denied that he was suicidal. So he said, yeah, everything she told you is true, but
it's theatrical.
Correct. I'm not going to kill myself. I'm not suicidal. The officers, however, they were worried about him. They thought that he posed a risk of harm to himself or others, and so they called an ambulance, and Caniglia agreed to go to the hospital for a psychiatric evaluation, but only after.
Would you say he consented?
No. Well, he consented to go for a psychiatric evaluation.
Okay.
But only after the officers allegedly promised him not to confiscate his firearms. So they're sitting on the front porch.
So don't take my guns.
Correct. He says, I'm not suicidal.
You pinky swear that you won't take my guns.
Pretty much. So he's sitting on the front porch. He says, yep, everything my wife told you is true. No, I'm not suicidal. They're like, will you go talk to a doctor for a psychiatric eval? If we call an ambulance, he's like, I'll go if you promise not to take my guns. And allegedly the officers were like, sure. So just as soon as the ambulance had taken,
hiding their two fingers behind their back.
It's crossed, fingers crossed. It doesn't count. So once the ambulance had taken Caniglia away, the officers entered the house, seized his firearms. They were
on the direction of his wife.
No,
because that
not addressed
played into it.
Not addressed, but
should
they
have
were
addressed because the context matters.
They were guided to the firearms by Caniglia's wife.
They said, where are the guns?
Whom they allegedly misinformed about his wishes. The officers
were like, no, he totally said to take them.
Correct.
Oh, no.
Allegedly. Yeah. So the officers then...
Or she said that because
I don't know.
She didn't want to get in trouble with husband again.
I don't know. But allegedly, it is, hey, Ed wants us to take his guns. Can you show us where they are? She's like, sure. So
I understand why this happened.
The officers entered the house and took 2 handguns. Lots of cops doing things they shouldn't do in this episode. Man, it's not good. Well, Caniglia sued, claiming that the officers violated the 4th Amendment when they entered his home and seized his firearms without a warrant.
And they lied to him, and he's more mad about that.
Yeah. All right. So this proceeds its way through the courts. What do you think the district court said? Remember, this is a civil suit.
Which means
that we're not talking about crimes charged against him. We're talking about whether or not this is summary judgment, qualified immunity, whether or not 1983 case can carry.
I would say they didn't love it.
The district court granted summary judgment to the officers.
Really?
Yep.
Even with the facts that he just made one move.
So he's displeased with this. So Caniglia appeals to the First Circuit, who affirmed solely on the ground the decision to remove Caniglia and his firearms from the premises fell within the community caretaking exception to the warrant requirement. Citing the Supreme Court's statement in Cady, the police officers often have non-criminal reasons to interact with motorists on public highways. The First Circuit extrapolated a freestanding community caretaking exception that applies to both cars and homes. So accordingly, the First Circuit saw no need to consider whether or not anyone had consented to the officer's actions, whether or not these actions were justified by exigent circumstances, or whether any state law permitted this kind of mental health intervention. So they didn't even address those because they straight up said Cady allows this. Cady v. Dombrowski. So those three questions aren't addressed. So all that mattered to the First Circuit was that the officer's efforts to protect Caniglia and those around him were, quote, distinct from the normal work of criminal investigation and fell within the realm of reason and generally tracked what the court viewed to be sound police procedure.
So he was displeased.
And he appealed all the way up to the United States Supreme Court, who granted
certiorari.
They sure did. You're never going to believe how they started this. They started by saying
Dombrowski.
Close. Well, how did Dombrowski start? With the Fourth Amendment, right? So in this one, they do the same thing. So the Fourth Amendment protects the right of the people to be secure in their person's houses, papers, and effects against unreasonable search and seizures. And at the very core of this guarantee is the right of a man to retreat into his own home and there be free from unreasonable government intrusion, which comes from
case law.
Yes, Florida v. Jardines.
Oh.
Yeah, that's a specific quote from Florida v. Jardines.
I should know that because that's a recent Nuts and Bolts episode.
That's why I put it.
I screwed it up.
Served that one right up to you.
And I'll let it fall.
All right. So the United States Supreme Court said, to be sure, the Fourth Amendment does not prohibit all unwelcome intrusions on private property, only unreasonable ones. We have thus recognized a few permissible invasions of the home and its curtilage. Perhaps most familiar, for example, are searches and seizures pursuant to a valid warrant.
Yep. Didn't have.
Yep. We have also held that law enforcement officers may enter private property without a warrant when certain exigent circumstances exist, including the need to render emergency assistance to an injured occupant or to protect an occupant from imminent injury.
Didn't have that. He's leaving.
Sure didn't. And of course, officers may generally take actions that any private citizen might do without fear of liability. Jardines, again, right? Like approaching the home and knocking on the door. Curtilage.
Not bringing your drug sniffing dog to the front.
Can't do that. The First Circuit's community caretaking rule, however, goes beyond anything this court has recognized. The decision below assumed that the respondents lacked a warrant or consent, and it expressly disclaimed the possibility that they were reacting to a crime. The court also declined to consider whether any recognized exigent circumstances were present because the officers had forfeited that point. Nor did it find that the officers' actions were akin to what any private citizen might do or have authority to do if Caniglia's wife had approached a neighbor for assistance instead of the police.
Yeah.
Didn't even bring that up. Neither the holding nor the logic of Cady justified that approach. True, Cady also involved a warrantless search for a firearm, but the location of that search was an impounded vehicle, not a home. A constitutional difference that the opinion in Cady repeatedly stressed. How many times did we just talk about it in this case, right? That it's a vehicle, not a house. Vehicles and houses are different. In fact, Cady expressly contrasted his treatment of a vehicle already under police control with a search of a car parked adjacent to the dwelling place of the owner, right? So they even said, like, not only is this not a house, this specific car wasn't even parked next to the house of the owner.
Like Collins v. Virginia.
Yes. Exactly.
Commonwealth of Virginia.
Yes. Cady's unmistakable distinction between vehicles and homes also places into proper context its reference to community caretaking. This quote comes from a portion of the opinion explaining that the frequency with which vehicles can become disabled or involved in crashes on public highways often require police to perform non-criminal community caretaking functions, such as providing aid to motorists. Right? So your house isn't going to become disabled or crash into another house, right?
But how often is your husband going to be histrionic?
Good word. Look
like
at
that?
you. That was real good. But this recognition that police officers perform many civic tasks in modern society was just that, a recognition that these tasks exist and not an open-ended license to perform them anywhere. What is reasonable for vehicles is different than what is reasonable from homes.
Mm-hmm.
Cady acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. That specific quote is littered through so many different Supreme Court cases.
Why don't you say that again into the camera?
Yes, the court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. That phrase is tattooed all over so many Supreme Court cases.
Is it tattooed on you?
No, not yet.
Okay. We'll find out if we get to 500 subscribers when he takes his shirt off.
I'm not taking my shirt off. We thus
We're creeping there.
vacate the judgment below and remand it for further proceedings consistent with this opinion. It is so ordered. So, though, this is strong. Remember, this is a unanimous decision by the Supreme Court, and they straight up absolutely not.
Yeah.
There is no such thing. There's no such thing as a community caretaking function when it comes to somebody's home. Doesn't exist. Not a thing. Don't do it. Don't try to use it for justification.
To go into somebody's home.
Correct. For a warrantless entry into somebody's home. Yes. There's no such thing.
For the home itself or for occupants of the home. They don't get into that.
No.
Because like going into the home to help the person who's laying on the ground that you can see.
Exigency.
Okay. So they just completely separate it.
Correct.
Okay.
So, and we'll get into that here in a second. But the punchline is community caretaking, as we have talked about it and we have understood it to this point, does not apply to a home. Period. End of story. Not a thing. Don't do it. Not a thing. Don't use it to justify your warrantless entry into a home because you're wrong.
Mm-hmm.
Don't do it.
This does not exist.
Yes.
None of us like it.
Yes. The court unanimously held that the doctrine does not justify warrantless entry into the home merely because the police officers are performing non-criminal public safety functions. The case reinforced the principle that the homes received the highest level of Fourth Amendment protection. In his concurring opinion, Chief Justice Roberts emphasized that existing exigent circumstances doctrine already allow officers to act in emergencies without creating a broad community caretaking exception for homes, because there are
very specific.
Correct, because their exigency may fall within community caretaking, but not all community caretaking is exigency. All squares are rectangles, not all rectangles are squares, right? It's the same sort of argument. So
they'd put that in the opinion.
That'd be great.
That wouldn't have been floral poetic.
No, it wouldn't have been. So that's community caretaking, man. And hopefully understanding of
this
Cady.
is the brief start of community caretaking, because there's certainly more
there's
cases
tons more.
we're going to be getting into.
These are the two titans, right? Cady v. Dombrowski says that, community caretaking, when it comes to an automobile, you can make that argument and specific set of circumstances based on the totality of circumstances. And if you happen to come across evidence of a cop who murdered somebody for a reason unknown, it may be admissible into evidence. And then in Caniglia v. Strom, the Supreme Court said, not a chance. That's not a thing for the House. Stop it.
Yeah.
So that's it, man. That's all I got for community caretaking. Two really important cases, and ones that I think...
so you would absolutely say to an officer who sees a garage door open, don't go in there.
Don't at all go in there.
Without consent.
Exactly.
Don't do it.
That's kind of the track that I was just go down is, man, I don't know how many cops really understand Caniglia v. Strom. I remember when it came out in 2021, I remember being like, well, that's going to change a lot of things that I do, right? It really is. So
do not go into the garage to shut it because you're trying to help them out, because you might see a dead body and then you're hosed.
Yes. So there is no community caretaking function. And I think that has been used as a catch-all by police for a really, really long time.
I'm sure the comments will reflect that.
Yeah. And they're right, right? There's a lot of circumstances where police use community caretaking as the justification for taking action, right? Sometimes, as in Cady, the courts say, that's good to go. But man, it does not apply to a home. And hopefully going that far into depth on Cady gives you a good understanding of why they said that can be an applicable thing, right? And it's not carte blanche.
No.
But hopefully that gives our police officers a bit of a better understanding and put you on notice if you didn't, that if somebody tells you that you're doing a community caretaking function in a house, alarm bells should be going off in your head.
Say, no, I'm not.
No, I'm not.
Is this exigency or not?
You're correct. Caniglia v. Strom says I can't do that anymore.
Nope.
So that's all I got for you, man. Thank you to our listeners. I know this was a bit of a longer one. Last week we kind of gave you a brief relaxation from the long episodes, and it was a little bit shorter. This one's going to be a little bit longer, but thank you so much for sticking with us and sticking all the way to the end here. So you want to tell them about our different platforms and where we can be found?
Yeah. Again, now we've switched to Spotify, so you can, if that's your preferred platform, you should be able to see the video now.
Yeah.
So that's a major bonus because I do spend quite a lot of time on it. Although I am still an amateur, that is a lot of the time that we take on getting these things in a more appealing way because, again, some of these court opinions and details are a lot.
Yeah.
So we try to break it up with some visuals, and it helps me when you get into those quotes to see it on the screen so I can kind of follow along, and I hope that those that are listening can as well.
Awesome. You got anything else for the people, man?
Drink more water. Hydration is important. Also, your watch does not match your outfit, and it upset me. But it matches my Memorial Day shirt.
Well, my shirt is blue. If it matches you,
yours
how does it
black.
match me?
That strap looks black.
The strap's black.
Okay, doesn't match.
I think it'll finally catch it.
Ugh. Yeah, unfortunately, I can see that it is.
Yeah, excellent. Gosh, that's so good.
All right. Thank you guys for watching. Thank you for a few of you that have stuck through almost every episode and comment regularly. Awesome. We really appreciate the community that we're slowly building here.
Yep. All right, guys. Thank you again. We'll see you in the next episode of Cuffs and Case Law, where we read case law so you don't have to.
It almost looked awkward to start, but...
What did?
Because
you demanded
it's like bam.
You demanded that I stare awkwardly at that center camera.
I didn't say do it awkwardly. I just said
said stare
look.
At it. You didn't say look. You said
gaze.
Stare right at it, right into its soul.